Good afternoon. I'm Ron Weich, the Dean of the University of Baltimore School of Law, and I'm very pleased to welcome you to this afternoon's webinar, which will examine the technology behind different kinds of forensic evidence to explore whether it is really as reliable as prosecutors, courts, and juries tend to believe. I'd like to welcome our special guest, Professor Brandon Garrett from Duke University School of Law. And Professor Garrett will be more fully introduced by our moderator. But I'm going to exercise the Dean's prerogative to introduce and brag about the other panelist, our new UB Law School faculty colleague, Professor Erica J. Suter. Professor Suter recently joined us to direct our Innocence Project Clinic, which is a special partnership between our law school and the Maryland Office of the Public Defender. We established this program some years ago, and it's been directed by Professor Michelle Nethercutt, and now Professor Suter will take over the reins of this important project, and we're very pleased and proud to have her with us. She comes from private practice, where she's been widely recognized as an accomplished appellate and post-conviction attorney. And in addition to the practice of law, she's gained experience working with students at Georgetown University and at the University of the District of Columbia's David A. Clark School of Law. Moderating today's discussion is our colleague, Professor Colin Starger, who helped create and lead the law school's pre-trial justice clinic from 2016 to 2019, as well as teaching cutting-edge courses in our school, such as coding for lawyers and the legal data and design clinic. This panel discussion is really a return home for Colin, because before he joined our faculty in 2010, he worked as a staff attorney at the Innocence Project at Cardozo Law School in New York, where he was lead counsel on 4 DNA exonerations, including one from Oklahoma's death row. I'm also pleased to share that in a few weeks, he will begin a 3-year term as our Associate Dean for Academic Affairs at UB Law. So let me turn over the microphone to Professor Starger as he introduces today's discussion.
Thanks, Ron, ever so much. And hi, everyone out there. For those of you that haven't been on these kind of webinars before, I'll let you know that you can see us, but we can't see you. So we encourage you to sort of use the chat function. And we're all here imagining that we're in the same room together and looking very much forward to the time when we all will be able to meet in person again, which I think is just around the corner. So I'm very excited to have this discussion today about bad forensics, how faulty evidence leads to wrongful convictions. And I would like to pause just a second to more fully introduce Brandon Garrett. I'm proud to say that Brandon is an old friend of mine. I've seen him play heavy metal music in New York City bars. He's an amazing metal guitarist, but he's more likely known to many of you as really one of the leading scholars of wrongful conviction in the whole world, certainly his generation's leading scholar. His book, Convicting the Innocent, is a true classic. It's must read. It has been widely cited in courts and scholarship, both activist and sort of litigation driven, and is really in many ways defines the field. We're here today to talk about his latest book, Autopsy of a Crime Lab, which is destined to become a classic as well. And I think you'll get a much better understanding of the substance of that throughout our discussion today. He's, of course, also the Neil Williams Professor of Law at Duke University School of Law, and he directs the Wilson Center for Science and Justice. So welcome, Brandon, and welcome again, Erica. Why don't I just get us started off, since a lot of the folks here that are participating in the webinar, listening to the webinar, might really not understand the stakes in kind of its human terms. And I wonder if you both might start us off by telling a story about somebody who was affected in some way by faulty forensics. And Brandon, I know in your book, you open the book and return to frequently the story of Brandon Mayfield. So if I might ask Brandon to talk about Brandon, I'd love to do that. And then perhaps turn it over to Erica after that.
Great. And yeah, I'd love to start with that story, since it's how I decided to introduce the book. And there's a reason why. It's just, I talk about stories in each chapter. I talk about cases of innocent people who I came across by accident, just reading forensics transcripts Our country, unfortunately, is littered with the cases of people who were convicted based on false or faulty forensic evidence. The developments occur every week. I could update the book every week. Just this week, Rachel Rollins, the district attorney of Massachusetts, announced that they're moving to reopen another 70,000 cases tainted by misconduct at 2 drug labs. And we'll talk more about how to fix forensics. But imagine what would happen if a local hospital said, oh, actually, we got 70,000 cases wrong. 70,000 COVID tests. Those were wrong. Sorry. We'll do better next time. And so, large labs operate at scale, and to have tens of thousands of cases, entire labs have been closed. Those of you who live in closer to the, DC metropolitan area, that lab is now closed. Its certification has been suspended. But when I first came across cases involving problematic forensics, a case I worked on early when I was in practice before I went into academia involved a bite mark in a case on Staten Island. But I feel like, in the media here and there, we've read here and there junk science stories. As lawyers, we know that there can be junk science, and we have rules like Daubert to keep it out. And I figured bite mark. Like having dentists testify in criminal cases, that's an outlying thing. It's a weird discipline. Dentists don't really belong as experts. They should just clean our teeth and, do our fillings and stick with that. And there are not that many cases that involve people biting other people. Our kids may bite us when they were toddlers. My kids had a biting phase, but criminal cases where that happens, not so common. I assumed even, as I began doing work on wrongful convictions and academic work studying them, that the bread and butter of what crime labs do, like the drug testing, which is about half of what labs do, and then fingerprints and firearms comparisons, which is a lot of the other half of what labs do. DNA testing, that's like a tinier slice. Figured fingerprints and firearms, that's like bread and butter stuff. Hundreds of thousands of cases a year, but that's got to be the basically reliable. Like fingerprints are so detailed. I've looked at my fingerprints. We used them to unlock our phones for a while, and then then there were problems with that, and so they stopped doing it. And that's why I start the book with the Brendan Mayfield case, because everyone thinks fingerprints are unique. It's like a metaphor for uniqueness. And here's this case of someone who is a lawyer, very sympathetic, outrageous charges against him. And he's in this federal court in Oregon telling the judge, like, that's not my fingerprint. And his fingerprint had been linked to a high profile terror attack in Madrid, the Madrid subway bombings that killed almost 200 people, explosions in the Madrid subways. This was like lots of mass terror attacks ago, but back in 2004, this was, national news, and there was a global manhunt for who was responsible. But this lawyer in Oregon, he'd never been to Spain. And what I like about the case as an illustration for what can go wrong with forensics is that prior to that time, there had been known errors in fingerprinting, and yet fingerprint examiners described having 100% certainty, 0% error rates. They were infallible. Fingerprinting, gold standard. They called DNA fingerprinting in the early years because maybe DNA could someday be as good as fingerprinting was the idea. And this was not a case where you could say, oh, well, this was like a corrupt analyst that was trying to frame an innocent guy. And there was biasing information. They knew that Brendan Mayfield was a practicing Muslim, and a criminal defense lawyer, you can't trust them. And a Muslim criminal defense lawyer, he must be a terrorist then. But these weren't like, this wasn't some corrupt lab. This was not like some small police lab that was unaccredited. This was the FBI, which is the cream of the crop, the world leader in forensics. And it wasn't just one FBI examiner. They brought in 2 other, I think both were retired, but senior former FBI. They brought in 3 examiners total to look at the fingerprints in this case because it was so high profile. They wanted to help the Spanish authorities crack this big one. And so you couldn't say that they're inexperienced. You couldn't say that they didn't have the training. These are top trained people in a case that could not be more high profile. They all agreed 100% identification. But then the second thing that makes the error so shocking and troubling is that we all tend to also think not only are fingerprints great, but fingerprints today particularly great because we have technology. Many people assume that, well, they have like computers now, right? And like when you watch like CSI type shows, they like the fingerprint match is done on a screen. It's not done on a screen. And if those of you, had frustrations like I did trying to use your finger to open up your iPhones, like often like your own finger doesn't open the phone. When you have a latent print from a crime scene, there's a lot of information missing And so it's the same as if your finger is wet and you're trying to open your phone. It's not a pristine print, and therefore you can't open the phone. Well, same thing with the latent print that was on the plastic bag that these unexploded detonators in a white van outside the Madrid bombing. You know, it's not like the terrorist who committed that attack was trying to leave a really good print on that plastic bag that was left in the white van parked near the scene. They should know not to use a white van, but it was a really low quality print with a lot of information missing. It did look a fair amount, actually, given what information was there. It looked something like Brandon Mayfield's print, but there's no way that you match a print from a crime scene to someone who lives halfway across the world in Portland, Oregon, who's never been to Spain. The only way you do that is because you have a database, a huge database using an algorithm that linked an innocent person's prints, because its job, the algorithm's job, is to look for prints that look as much alike as possible. And in some ways that makes the job of a forensic examiner easier. Without a database, if they didn't have a suspect in mind, then there's no one to compare the prints to. Like, we don't know who to compare this latent print to. We don't have a suspect. That's how it operated in the old days before databases. But with the databases, you can match prints to people all around the world. And not only that, you're going to be matching it to prints that look a lot alike, a lot alike. And so the danger of a coincidental match to a print that belongs to an innocent person is vastly amplified the bigger the database is. Often the approach has been the more biometrics, the better. The bigger databases, the better. Lots of federal money has been poured into expanding the size of biometric databases, DNA databases, and the like. The bigger they get, there may be more coverage, but vastly amplified chances that someone innocent like Brandon Mayfield can get ensnared, which is what happened to him. He was, arrested, detained on a material terrorism warrant. They actually brought in a defense expert, and he tells the defense lawyer, like, I'm sorry, I looked at what the FBI experts did. Seems right to me. And of course, he looked at the same markups that they had done. Later, when there was an inquiry, you could see the circular reasoning and how they changed their mind about some of the marks, because they're all driven to find a match. They were match oriented. But anyway, there's a lot to say about the role that bias played, the issues with the vagueness and challenges of doing fingerprint work at all, the role of the big database. But the case created shockwaves because the Spanish authorities later linked the print to a known terrorist who actually, was in Spain at the time. That was definitely a mark in favor of that suspect. And now Brandon Mayfield, they told the FBI, like, we have no idea what you're talking about. You're clearly wrong. We know whose prints these are now. The FBI eventually apologized to Mayfield, paid a civil settlement, and did a full inquiry into how this went so badly wrong. And it just highlighted all the ways that forensics can go wrong, even in the most high-profile case where the top experts are brought in, and you're using a technique, fingerprinting, where everyone had said in court for decades, these experts said that they were infallible, 0 error rate. If the technique is done properly and this isn't some inexperienced, corrupt buffoon, we get it right, always. It's fingerprinting, we're perfect. And that was, this case blew the lid off of that. There's similar cases like that in other countries, really high profile fingerprint errors. And then that sort of raises the question, well, if fingerprints can go wrong, well, how often does it go wrong? What if it's not an FBI examiner? What if it's even worse quality evidence? What if it's a worse or more biased set of database matches? How about all the other forensic techniques? And that's sort of how I begin the book. If even 3 examiners from the FBI with a decent quality print and a really good database can get it so terribly and completely wrong, how about all the other cases? And of course, we know something about how about all the other cases. We have 70,000 cases being reversed in Massachusetts potentially right now. We have the DC lab shuttered for the time being. We know that there are a lot of other cases. And so that's the problem of autopsy of a crime lab, to then walk through all the different ways forensics can go wrong, where our starting place is, come on, it's an expert. Fingerprint, perfect match. That's what they've told us they can do. They can match the stuff. They're matchmakers. Not at all. And that's what's so troubling about what the sort of the sausage making that goes into this expert testimony that seems so accurate on the surface, but really is hiding a whole swath of different problems, from the crime scene to the lab to the courtroom.
Well, thank you for that. I mean, and it is a perfect metaphor because it falls and pulls into so many of the disparate parts of a big problem. And we'll ask you shortly to elaborate a little bit more on some of the problems around pattern matching and how what real science fits into this. But before I do that, I want to turn to Erica. Brandon had just mentioned that about half the work that labs do has to do with drug testing, and about half with fingerprinting and firearms. And I know that you've worked on a case that involved firearms tangentially with a composite bullet lead analysis. And I wonder if you could tell a little bit of that story to, again, just give a human face to the problem that we're talking about.
Sure. So I had a client in Prince George's County who was convicted in 1994. It was a convenience store robbery where the owner of the convenience store was shot and killed. And it remained unsolved for a while, but ultimately my client was arrested and convicted. And the really only evidence against him was CBLA, comparative bullet lead analysis, and the testimony of a jailhouse informant. So yes, Brandon's nodding. Yes, the good old jailhouse informant. So for those who don't know, comparative bullet lead analysis is now a debunked science. Basically, in the simplest terms, what the FBI was testifying to in court was basically that bullets in a batch were sort of elementally unique, such that if a bullet was removed from a body, as in this case, and then a bullet was found, let's say a bullet was found in my pocket at a totally different time, that they could compare those two bullets, the composition of the bullets, and say definitively that they likely came out of the same box of cartridges. And therefore that sort of constructively these bullets must have been in your possession. And of course that's not true for a whole host of reasons, but for a while this was testimony in court. So in my client's case, there was a bullet removed from the victim in this case. And years earlier, a warrant in like a drug raid had been served on my client's aunt's house, and he was living there at the time, and there were some bullets found in his nightstand. And that was where the bullet came from that was compared. And an FBI expert testified and said that they must have come out of the same box. The other piece of evidence against him was a jailhouse informant that said that he confessed. So, I mean, it was known at this point. I'm thinking, oh, this case is going to be blown wide open. We all know it's well established. It's not in dispute that comparative bullet lead analysis is a bunch of junk. And so we filed a petition for writ of actual innocence years later. And the state was not conceding. And it wasn't until we did an MPIA request where we found out that our informant, who had testified that he wanted a benefit but never got one in this case, he just wanted to do the right thing, this was weighing heavy on his soul, was actually a career informant and had gained favor from the U.S. Attorney's Office before, and that this was conveyed in writing to the state's attorney's office, and none of that had been turned over. So once we had these two pieces of information, the state fortunately conceded that the client was entitled to a new trial. But it's even sometimes when you've got sort of the forensic smoking gun, it's not enough. You have to push for more. But it's shocking, I think, to think that sort of baloney is peddled to judges and juries, and that client was serving a life sentence.
Yeah, that's incredible. And really, in many ways, your story connects to Brandon's in that in the Brandon Mayfield case, the fact that they were able to identify the actual person that did it became that plus that made the FBI finally realize, wow, we really did make a mistake. And in your case, when you were able to uncover information about the informant that haven't previously been in there, they're like, oh, well, that plus the faulty forensics makes a problem. But you're right.
Yeah.
It's not just the forensics alone that doesn't seem to carry the day. Do you agree with that, Brandon?
Well, and also another one difference is that like the FBI has never said, oh, fingerprinting, wow, it can go really wrong. We're really concerned about the reliability of fingerprinting. The Inspector General's reports and the like sort of studiously avoided the question whether this raised larger questions about reliability of fingerprinting in general. The FBI did create some new quality controls, like having a blind separate evaluation, but just in cases where there was a single fingerprint, like in the Brandon Mayfield case. So like a good protection, but only in a limited number of cases. One difference, though, is with bullet lead, the FBI stopped using the technique after the scientific community came together and said like, there are no statistics here, there's no science here, reaching conclusions that are wholly unsupported by any method. This should not be used in court. And the FBI, agreed, okay, this is, we've been making this up. We shouldn't be making up forensics anymore. And so they stopped the technique. But nevertheless, so the scientific community has come together to say that this is unsupported by science. Why should I care as a court? It's been amazing to me to see quite a few reports, like say by the National Academy of Sciences, the Presidential Council for Advisors on Science and Technology, the PCAST report on forensics. Lawyers have even struggled to introduce those in court because judges have actually said that they don't count as learned treatises. Like some evidence casebook can be a learned treatise, but something by the leading scientists in the country, and then the leading scientific institution in the country, the National Academy of Sciences, that's just scientists. That's not a learned treatise. And so there's just a problem of science literacy that extends
I'd love to ask
to many of us in the legal community. That's a different topic, but
and that's a topic I would love, in a way, to ask you to expound upon just a little bit, because you've really studied the history of and evolution of forensics, and we know that along the way there have been some admissions that certain things are indeed junk and we won't use them, and other things maybe we won't look at it. But I was wondering if you could give us both a sense of how it is that we got to where we are now, but how much is the history of pattern matching, which seems to be kind of at the core of all of these forensic disciplines. How much is that rooted in what we might think of as science, or what are its scientific, places in which it might approximate it, and places in which it doesn't resemble what scientists would actually consider science? And that goes to a question that's also in the chat a little bit. I'm not sure if you had a chance to see that.
Oh no, I missed that in the chat.
Don't worry,
I'll look at the chat now.
Yeah.
But lots of us went to law school. Colin, you had a background in working with data and doing things that were scientific before law school, but most of us did not. And most judges don't have a science background either. The Supreme Court was even somewhat cognizant of that in deciding Daubert, like, oh, wait a minute, we're going to be asking judges to answer questions about scientific methods and the like. But then again, we allow experts to do things on the stand, which traditionally normal witnesses don't get to do. Normal witnesses, lay witnesses, don't get to offer highly conclusory opinions about much, except they're someone's reputation for having a trustworthy character, or someone's just everyday observations. We allow experts to do a lot more, and the only reason we allow them to do that is because they're supposed to actually be expert at something. But traditionally, we often let in experts without any real understanding of what it means to do something reliably. And so if someone said, like, I've looked at lots of fingerprints, and so I can match this person's prints to that person's prints, judges sort of said, oh, okay. There's even been a history in some techniques where actually some initial experts will testify quite carefully and say, there's a wonderful genealogy that Michael Sachs led this whole team, that it was an amicus brief and then an article looking at the case law, where there was a famous case in California I talk about in the book, where these two dentists looked at a bite mark and they said, this was normally like human bites. If my kids had a biting phase, like it just kind of turns red. Like you can't tell much about the shape of the teeth that made the bite. It's just like your skin hurts and it's red. But these dentists in this California case said, well, this is a bite on someone's nose. Like this is like, because it was on a nose, like there's a lot of information preserved because of the cartilage that got bit. And so it was an unusual, gruesome, and they sort of said, like, normally you would never reach conclusions about a bite mark. Come on. But because this is on a nose and there's an unusual degree of detail preserved, we feel like cautiously we can say some things about the teeth of the biter, but we would never generalize this to other types of situations. The court let it in, and then courts all around the country said, oh, California case, let in bite mark testimony. Bite mark testimony, go ahead. This is an accepted technique. And so it's, the similar to problems of dicta and opinions becoming accepted by other courts without looking at what was the basis for that language in the first opinion. You have a court let in evidence and find an expert admissible, and all the other courts say, oh, expertise, this must be expertise. And so it's a problem of a system that relies on precedent and not based on scientific research. Or you could have, the FBI disavow bull lead, but courts say, well, it's precedent in our jurisdiction to allow bull lead. It doesn't matter that scientists say it's totally flawed. we don't rely on science, we rely on precedent. So that's been something of a problem. It's been, some lawyers become understandably dispirited because there are entire states where there may be a forensic technique where the courts have taken judicial notice even, which is not really a proper use of judicial notice, but they'll say, oh, judicial notice that, firearms get in, that fingerprints get in. It's not even a topic that's up for serious discussion. We will not have a hearing. We will not look into the issue. There's nothing to talk about here. I've done a lot of work surveying mock jurors and lawyers. It makes a big difference, for example, for the defense to have their own expert to educate the jury on what the limitations of a method are, even if the defense expert doesn't look at the evidence and come to a different conclusion. But judges typically, why would you have another expert? Like, this is science. It's, it's fingerprinting, it's firearms. Why would you spend money on another expert in the same way that you would if it was a defense request to have a psychiatrist examine the client? And no, we're not going to trust the prosecution psychiatrist. We need our own psychiatrist. Well, with many of these forensic techniques, the defense doesn't get an expert. No funding is awarded for it. The idea is, oh, well, no, this is a match. Like, how could anyone disagree? So there's lots of inertia built into the way we do scientific evidence in criminal cases in this country. We can draw the contrast with civil cases where there's a very different culture, where there is often a battle of the experts, because it's not, life and liberty that's at stake, it's money that's at stake, and money is much more important. And therefore both sides, you get under the civil rules, you get depositions, both sides retain experts, you get detailed expert reports, what evidence the experts relied upon. You can pick apart the publications that they were citing and ask them questions in the 8-hour depositions. There's lots of litigation over experts, and judges are much more skeptical of expert evidence because they see two sides. Criminal cases, they don't see two sides. They see a report that may have a one-line conclusion saying this was identified as coming from the person's finger, or this was identified as having come from the same shotgun. There are no bench notes, no documentation, no literature cited, no depositions, no nothing. And so, judges and lawyers are operating in the dark, and with predictably terrible results.
And that distinction between civil and criminal is very, very disturbing. And the fact is, it's not just life and liberty, it's almost inevitably life and liberty for poor people, and very often people of color, and that twin standards of justice, or really injustice for some, injustice for others, deeply disturbing. Erica, I wonder if I might ask you some of the general questions around admissibility and the state of science that Brandon has given us a national picture on. Do you have any thoughts on how that picture looks in Maryland, in terms of what gets in, what doesn't, where you think, how much junk do you think gets in, and what's the role of experts here?
Well, we've just become a Daubert jurisdiction, or Daubert jurisdiction. I always struggle with that. So it's really, I think it really remains to be seen how that is on the ground going to impact what's getting in and what isn't. I think education is a huge challenge in terms of sort of getting the court to understand, what things are in fact not infallible. One of the things that Brandon talked about in his books, one of the expert issues that, of course, most Marylanders, or at least Maryland lawyers, are familiar with, is Joseph Capera, right? And that is really an example of expert testimony gone awry. And I was just checking with other folks in OPD, because Joseph Capera was a firearms examiner in Maryland, who was based in the city but testified all over the state, testified federally, had a fantastic reputation, and would tell the juries in this very persuasive way why this bullet matched this gun, and brought out his big old wooden model of a bullet to show the juries. And in a post-conviction case, somebody from the public defender's office, who's Andrew Way, had been sort of digging in and asking him about his qualifications. There'd been some questions in the past, but he was very slick and convincing, and was able to kind of put them off. And he had faked his credentials. He had faked where he went to school, and she pressed him, and he came up with some fabricated transcripts. And she followed up with the registrar, I think it was University of Rochester and University of Maryland, and some other falsified credentials. And when it became obvious to him that this was sort of coming to an end, he committed suicide. And when that happened, I think a lot of us defense attorneys thought, oh, this is going to be a really big deal for these cases where he's testified. And to date, And this happened in the Kulbicki case, which is now a petition for writ of actual innocence in 2020, was granted, but actually based on CBLA and not the compara stuff. But I don't think that there is a case, I'm not aware of a case yet in Maryland where a defendant has gotten relief based on the fact that this officer testified falsely. And the court is saying, well, he falsified these credentials, but he didn't need these credentials in order to testify. This is just based on experience. So even though we all know that this man is a liar, that's not enough. And then in 2020, it came out that he's actually forged signatures of supervisors on his work. And I think it remains to be seen, but as of right now, it's just shocking to me that in and of itself, where that evidence might have been critical, is not resulted in relief for anyone. And so I think it's an example in our own state where things have really gone tragically awry when we're just sort of buying what the expert is selling.
And that's, I would add to that, like, it's not a trivial thing to forge the supervisor's initials, because the purpose of having a supervisor look over your work is to provide something independent to verify that you actually, follow the right steps. Now, what that verification really means in a firearms case is pretty thin. I mean, Maryland, in some ways, it shouldn't matter whether the firearms expert committed misconduct or not. You should be re-examining every case in which someone claims to be able to say that I found a match to this gun. Because traditionally offices don't document their work. It's not even like a problematic fingerprint examination where there are at least markings showing these are the minutiae that I identified on this print, and then I found some of those same patterns, and here's my markup of the suspect print. Nothing is marked. It's literally just eyeballed. Like the scratch marks are looked at side by side, and oh, they seem to line up enough, and if there's some differences, they're not big enough. And how many differences do you have to see for it to be big enough? How many do you have to line up? What degree of matchiness of the scratches do you have to observe? Based on my experience and training. And how often do you get it wrong? How rigorously are you tested to find out whether you are good at lining up scratches? And how often do scratches line up pretty well between guns that are actually different? Or no idea. Now that error rate studies are being done, we know that the error rates can be quite high for this type of firearms tool mark comparison work. And we have no idea whether someone who's worked for years or has better credentials is better at it or worse at it. Who knows what credentials make someone a good firearms and tool marks examiner? But this person could have lied and said, I've taken every international certification on firearms. Who knows whether even that makes a difference, because then the technique itself is fundamentally it's not validated. Now, there have been a couple recent decisions, including in Maryland, where courts have said, lower courts should have looked at these reliability questions more carefully. But there's a fundamental problem with the technique, and it shouldn't take gross misconduct, like in this examiner situation, to look at the entire discipline. Unfortunately, courts have often only done that in serious bad apple situations, but we just have no idea how bad it is. I mean, the closure of the DC lab occurred because in one case, it was the prosecutors, the U.S. Attorney's Office in DC, that asked for an independent examination of a firearms comparison, and they brought in two outsiders to do one spot check. And they did their spot check and said, no, these cartridge cases did not come from the same gun. Your lab person got it wrong. And then the lab sort of changed their conclusion to inconclusive, so that they were like, well, now we can't be right or wrong. We now say it's inconclusive. And others were brought in the lab to try to verify this. They changed their conclusions. This whole scandal erupted as part of like a weird cover up of this error. But what if that spot check hadn't happened? Or what if in Massachusetts they did a single spot check of one of these drug labs, before 100,000 plus cases got affected? Could they have detected that these two drug labs in Massachusetts had were the drug examiners, some of them were using the drugs and not testing it, the machines were contaminated, like all their work was flawed for years and years and years. A single spot check could have prevented tens of millions of dollars from being spent to unravel this huge problem. But we don't do even the most basic quality assurance to find out how good individual examiners are, or how good labs are, or how good techniques are. And that's the kind of top to bottom reform agenda that we need. And instead, we sort of respond haphazardly here and there to a wholly discredited technique, a wholly discredited examiner, without looking at whether entire disciplines have anything to them. And, even if some examiners do reliable work, we have no idea which ones those are because we're not actually testing them.
I just want to draw the panelists' attention to a lot of great things happening in the chat. Marty Tankliff is here and is saying hi to both Brandon and Erica, an exoneree and a really important member of that community. There was a question, Erica, about if that's Ali Foreman in the back of your
Honey Liston,
frame.
first minute, first round,
First minute, first round. It's a good observation. People paying close attention. A lawyer named Eli Braun, you'll forgive me if I've mispronounced his name, has some specific, had a victory with Capera, but on the substantive testimony, not anything to do with his credentials. And there was a question that came up. I want to ask you a quick fire question. So I'll ask you a quick fire question, and then I'll go to one of the questions from the chat about reliability of other tests. The quick fire question is just, and I know you talk about this a little bit in your book, how much is what happens in labs at all like what happens on TV and your crime scene shows? Any thoughts on that?
My friends in labs could sort of appreciate being dramatized with like actors that wear cool leather jackets and clothing. And I mean, as lawyers, we really appreciate being portrayed on TV by people who are really attractive and dressed better than we do. So that's a good thing for a profession, to be glamorized a little bit. Unfortunately, I say in the book that actually like what's on TV and what experts say on the stand is often equally false, that they claim to find a perfect match in the courtroom and they can't. And on TV, they claim to find a perfect match. Although at least on TV, they pretend like there's technology and there's statistics and there's computers involved. Unfortunately, more often in the real world, it's like someone who says, well, based on my training, I've sort of eyeballed it and it's a perfect match. So at least there's a nice myth that there's like actual, technology involved or statistics involved. And they'll say it's a 99.9977 match on a CSI show. Whereas in real life, it's someone who's really overworked, looking at screens all day, eyeballing stuff and saying, well, looks similar. Now, there are techniques that do involve machines and like drug testing where equipment needs to be calibrated and there is uncertainty and there are measurements. And so there are separate quality control issues with doing that work well, but at least it is based on chemical assays and there are statistics involved. That's about a half what labs do. But most of the other half of what labs do is this pattern evidence-y type stuff, which unfortunately doesn't work like TV. But in the courtroom, they say something like TV, which is perfect match. Source identification, they use different phrases for it, but basically the same idea. Match, I found a match.
Any thoughts on that, Erica?
Yeah, I agree with Brandon. It's definitely not like on TV. I think on TV, in my case, once it comes to light that my client's convicted based on this junk science, that's it. But no, there always has to be, not always, but often has to be more. Reading Brandon's book, it reminded me of reading a transcript where the fingerprint examiner testified, this is better than DNA because every fingerprint is unique. So you can rely on my testimony more so than science. And of course, everyone's like, oh, DNA, it's the gold standard. So you hear stuff that sounds like it should be in a movie when you're, when you're in court. But yeah, the reality is the lift for those of us who are kind of fighting, the tide of some of this is a lot more difficult than it is on TV.
But when I've surveyed lay people and asked, like, which is more unique, fingerprint or do you think that fingerprint work is unique versus do you think DNA conclusions are unique? More people say fingerprint than DNA. Like lay people put a lot of weight on fingerprint testimony. Maybe they think it's like, I don't know, it's like your individuality is expressed in your fingerprints, whereas DNA, that's like a number. Who knows what numbers are? Numbers repeat. So people place a lot of weight on these forensics. And when you ask people like, how often do you think they get it wrong with fingerprints, with firearms, with these different disciplines, people say like millions, 1 in millions, like astronomical error rates. But that said, when you tell people, well, actually, there's been like, there've been some black box studies done, like the error rate may be more like, 1 in 300 or 1 in 18, or then people are like, really? And people place a lot less weight on the evidence. Like we don't need to treat jurors like dummies and hide the research from them. And when we tell them, it's not like people have a problem of blind trust in science in this country, and or that we just blindly trust experts. People may be prone to convict people who are criminal defendants, and that's another problem. But But in general, people are skeptical of science, as you know, we have vaccine deniers in this country. And so when we tell people information about error rates, they can take that into account. And people are quick to turn on an expert if they realize, wait a minute, this person's just eyeballing it, and the error rates are that high. Well, okay then. And that's what we need to judges to permit the defense to do in the courtroom, and we need the actual data and research to start to unpack these pervasive problems.
Let me ask a question that's coming out of the chat, and maybe you can just give a comparison of different disciplines. Eugenia asks if all forensic tests are unreliable, and maybe I would say if they're equally unreliable. What disciplines do you think kind of maybe fall on the potentially relevant, or if done well, can be good? And which ones do you think, and this is to both of you, do you think really just need to be thrown out? We've already established that CBLA has been thrown out and should
Yes.
be. But what else?
Do you want to go first, Erica?
Well, I think one field that is traditionally very accepted that is so troubling given the subjectivity, and maybe that's sort of the hallmark of the things that we really need to look at and challenge and push back against, are the ones that have so much subjectivity going into the analysis. So if you look at something like firearms examination, tool marks comparisons, where, I mean, there's been some evolution in the field and some sort of refinement where they can no longer say definitively, even though they used to say this, that some particular bullet came out of this weapon. Traditionally, it is a field that is sort of respected in the courtroom. And I think there's a lot more room for error, human error and human bias than is sort of generally known by both judges and jurors. So I think that is a field that we all have to work to push back against, because it's opinions that have been offered that have been difficult, I think, to challenge in courtrooms.
Yeah, and I think, as we get information about error rates, we start to learn about these disciplines a little bit more. In the past, they may have all said perfect match, source identification. That all sounds the same. Maybe it's all equally reliable. And now we know that no, not so much. And so the PCAST report highlighted that, there's so little known about the reliability of bite mark examinations, and what we know is so problematic that, they suggested that foundational work needs to be done before this is ever used in court. It's not clear that you can even tell whether it was a human bite or just abrasions on a body. So that's on everyone's list of something that, how can this still be used? Some voice comparisons. Back in the 70s, the Academy said this is wholly unreliable. That didn't stop courts from letting it in for years to come. Bullet lead analysis, there's nothing there. The scientific community came together and said but then there are techniques like fingerprinting, where there can be a lot of detail on a fingerprint. We know more about error rates. We can disclose those error rates to the jury and continue to use it, but we still need to learn a lot more about, well, what if it's a really, really poor quality print and there's only one of them, like in the Brandon Mayfield case? Do we need to tell the jury a lot more and limit the testimony? Do we need to have a defense lawyer explain all the limitations? Judges may be more comfortable with that, and they may produce good results to really contextualize evidence. There are real concerns with some other disciplines. Blood spatter, we're learning more and more about just enormous error rates with that technique. And in general, the more subjective it is, the less information an expert has to go on, the more you're going to be worried that they're going to be easily biased, led astray by all sorts of biasing information. We're worried about biased policing in lots of other contexts, and forensics and evidence collection, CSI, all of this needs to be part of the conversation around subjectivity, bias, and error in criminal cases. I think it should be part of the police reform agenda. We need crime labs to be independent of the police. And then there's this larger project of whatever the technique is, whether it's really subjective, you need lots of guardrails, or more objective, you need fewer guardrails. No matter what, crime labs are capable of getting the most objective techniques completely wrong. Right? We've seen innocent people convicted based on false ABO blood typing, which is like the simplest technique in the world. We've known for, whatever it is, like 80 years how to do blood typing right. And that was falsified in lots of exonerees cases. So even a simple objective technique can be falsified, corrupted when you have really, really horrific quality control in crime labs.
So I want to turn to solutions in just a second. We've got about 15 minutes left in the webinar. Time is moving quickly. But before we do, I just want to switch to a slightly different topic and get your thoughts on this. when we think about forensics and problems in forensics, we don't ordinarily think about systemic racism. Uh, and yet there probably are really meaningful connections to be made. And it's a topic that's just so important these days. It's always been important, but there's just been a renewed impetus around it. And especially now that there's people bashing essentially a legal theory of critical race theory out there in the media. I just feel like it's incumbent upon us to bring it into the conversation a little bit. So Eric, I'll start with you, and then Brandon, I was just wondering if you might see what connections you think are worth making when we think about confronting systemic racism as part of what we're doing when we're thinking about flawed forensics.
So when we think about Maryland in particular, and we look at the fact that Maryland leads the country in imprisoning the largest percent of our Black population to any country in the United States, we have the dubious first prize in that respect, with about 30% of our population being Black and 70% of our incarcerated population being Black. There's no way around that. Systemic racism, that's a product of systemic racism. That's a product of slavery and of Jim Crow. So I think it's just not up for debate that is impacting our outcomes in our criminal justice system. And I think it's interesting because when we think about forensics and we think about science, we think about it as being objective and unbiased and the thing that's sort of reliable that can get us kind of beyond the question of race. But there are humans making these decisions who have biases. I mean, the most obvious sort of issue is when you think about cross-racial identifications and the amount of error that's sort of documented in those instances. But I also think when, who's going in a lineup, who's being selected, what are the biases in the information of the people who are making these analyses? I think it's all part and parcel of sort of contributing to the crisis that we have now in our system.
Right. And before turning to you, Brandon, with the same question, I will just do a very short plug to say that I'm the reporter for the Maryland Pattern Jury Instructions. And we just issued a new instruction on cross-racial identification to try to begin to get at that problem that you rightfully identified. But Brandon, your thoughts on this topic?
I think that forensics and it needs to be a part of our whole de-biasing program to address racialized injustice and mass incarceration in this country. Why is it that we have real quality control at hospitals? And if a strep test is done wrong, there'll be an inquiry, and there's proficiency testing. We have accuracy testing. Any company that has, a lab or does emissions that affect water or air, there is spot checking, there is auditing. And yet crime labs operate in this environment where they can just sort of do this matchmaking with no meaningful proficiency testing that actually tells you about how good the people are in the lab, not the kind of spot checking or auditing. They don't do surprise site visits. They don't check the work. How can you have that? Well, you can have that in a culture where, stuff involving putting people in cells potentially for the rest of their lives, or even in death penalty cases. We just don't care about quality control. We don't care about science. And so there just aren't the same guardrails that there would be in any real laboratory. You have clinical labs, carefully regulated, federal regulation. You lose your funding if you don't comply with the rules. And then there are crime labs, where voluntary accreditation at best. To have the kind of bias that you have, where you can have a detective calling the lab analyst, and they're not like a white-coated, professional, nerdy scientist just examining the patterns and just the facts. No, you can have the detective calling them saying, don't do a DNA test here. We have a guy who confessed. Or by the way, here's the guy's criminal record. It's as long as my arm. We need those prints. We need them fast. None of the kind of guardrails you'd have where you'd want independent science. It extends to the crime scene. And it's a reason why it needs to be part of our conversation about what is the role of police in our country. Why do we have laboratories that are connected to law enforcement? We need independent science. And it actually cuts against, one of the arguments that has been offered in response to calls to defund policing is, well, wait a minute. Communities need police to solve the most serious crimes, the murders. Fine, maybe we don't need armed people doing traffic enforcement, the millions of traffic stops we have each year. We don't need armed people to give out parking tickets. Maybe we don't need armed people to be mental health responders. Like, we need a different mental health system and behavioral health system in this country. But we have murders to solve. We have serious assaults to solve. Well, if you want to solve the serious assaults, the murders, you actually need independence of police there too, because you want that crime scene collection to be done by scientists, by professionals. And the biggest complaint by good lab directors is, we get this stuff, it's mislabeled, it's swabbed poorly, the scene gets totally contaminated. If only we had been there. And in some jurisdictions, you do have a crime lab oversight of evidence collection, but in others, it's just a mess. And then there's the question of, well, in what cases are we prioritizing forensics? It's common in death penalty cases, for example, you see this race of victim effect, where you have a lot of harsh resources invested in prosecuting cases where there are white victims. And you see the same with forensics, that from what we know, forensics are really prioritized in murder cases. Lots of tests are done in murder cases. You have heavy investment in forensics. And particularly, the murder cases where there is that heavy investment in forensics, it's the cases where there are white victims. A lot of the cases that I talk about in my book are cases like that. Often it's a white defendant as well, because so many murders are within race. But it also raises these questions. Where are we trying to do science, forensic science? Where are we trying to get it right? Why don't we care across the board? Why do we let it be a police function and not a science function? I think all of this needs to be part of our larger police and criminal justice reform conversation.
Thank you for that. I just want to draw a brief attention to an interesting and provocative comment in the chat before asking you guys to discuss solutions. And that comes from, again, forgive my mispronunciation if I do, Uran Itza Abbas, who says, considering this webinar is hosted by UBALT, which has a top forensic science program offering bachelor, master's, and certificate programs, what collaborations, if any, are UBALT Law School with Professor Starger and Suter engaging to encourage cross-communication and learning across UBALT schools and disciplines? I think that's an excellent question, an excellent point. And I want to be clear that we're not trying to say that all forensics are bad, not by any means. We're expressing a lot of the frustration that lawyers have with how it ends up getting incorporated into the courtroom and how wrongful convictions have resulted from that. But I do think that the fundamental point that there should be cross-communication and collaboration is a really good one, and one that certainly I'll be
and we want programs like UBALTs. We want people doing forensics work to have a science background and to have training. A lot of these disciplines grew up. I should have talked about this more when we talked about the history. Really, police officers put on desk duty saying, go look at the prints in the basement. The labs grew up in the basements of police departments, people from a policing background, because police were confronted with these cases where there was this trace evidence. And what do we do with it? I guess we should study it and see if we can do something with it, which was, laudable, but it wasn't people with a statistics or science background. And it's been a real change in this, especially in this country, to have more professionalized graduate programs in forensics, which is exactly what we want. We now have many more lab directors that have a hard science background. DNA helped because people doing DNA work really needed to understand statistics and genetics and the like. And that's been a really important part of some of the changes that we're seeing. Like, we really want crime labs to do good work in this country. We really want forensics to be used to clear the innocent and to apprehend the guilty. But to do that, we need to bring science into these labs. And a lot of the conversation today was negative. I promise that a lot of what I talk about in my book is also positive, highlighting some of the really interesting reforms that are going on now. I really am optimistic about the future of forensics, but we do have a big hill to climb.
So in the 5 minutes that we have left, I would love to get your thoughts, and I'll start with you, Erica, on solutions. I just want to apologize to the attendees. I have only been looking at the chat box. I didn't look at the Q&A box and haven't been addressing those. I will not make that mistake again if Chris is so generous to invite me to host another webinar. But Erica, what do you think about solutions in light of all that we've been discussing, the way forward? Do you share Brandon's optimism? And then Brandon, I'll give you the last word.
Well, I do have a lot of optimism. I think both of you could speak to the fact that good forensics and good science is critical in the world of wrongful convictions, and it's helped us to free some folks who were wrongfully convicted. Um, and I think it seems to me, and I really got a sense of this on kind of a macro level, reading Brandon's book, how important exposure in education is, and just introducing error rates and just pushing back and challenging our long held assumptions. I mean, I think most of us feel so strongly about fingerprints because we've always heard about them since we were little kids, whatever our age is. It's something that's just sort of part of what we've all understood to be science. And so I think pushing back on those narratives is important. I think being able to work with students, like I'll be working with in the fall, challenging these convictions and exposing students, some of whom may be defense attorneys, some of whom may end up being prosecutors, to think critically. I mean, I think that's sort of the issue, is to really sort of introduce some critical thought to the field and how we're looking at science. But I think there are plenty of reasons to be hopeful, but I think there's also a lot of things that we have to watch and push back on. New innovations like facial recognition software and all the problems that are there. We have a lot of work to do.
Thank you, Erica. Brandon.
Yeah, we certainly have a lot of work to do. I do think that hopefully we've had such expensive disasters in forensics, and not just expensive wrongful convictions of individual people, but entire lab shutdowns. Like we're seeing, it's like not a month goes by that we don't have a major audit or review or lab closure. I hope that people are it's finally hitting home. It didn't take this many scandals to redo how we handle clinical labs in this country. It's taken a lot more to make people care about criminal cases, unfortunately. But the expense and the costs are undeniable at this point. And I think that we will start to see regulation introduced to do simple spot checking and site visits and collect error rate information. And all this is, I think, starting to affect judges too. And surveying judges and talking to judges, we have a new generation of judges that are starting to think more carefully about forensics, because so often in the past, everyone just assumed it's a match. What's the problem? It's much harder to think that now that we're learning so much more about forensics. And nor are jurors going to throw out the evidence once they hear that a fingerprint could go wrong. I think that these studies are really helpful to understand how learning more about the strengths and limitations of the evidence can improve it. So I do think that it's going to be really important for all of us in the legal community, as we're the watchdogs, we're the lawyers. Those of you who are watching are law students and are future lawyers. Like, we don't have to be scientists ourselves, but we have to be scientifically literate, and technology will continue to change. There will continue to be new problematic forensic approaches that we'll have to master and get a handle on. We haven't talked that much about algorithms like facial recognition. There's the problem of pattern matchers who say, my head is a black box, but I tell you I'm experienced and I found a match. But there's also the problem of an algorithm, which is a black box, and the designer doesn't even know how it was trained to work. And the algorithm says it's a match. We have to worry about that too. And we have to unpack the uses of new technologies, which could raise lots of the same issues in terms of like, well, how reliable is this algorithm? How often does it match to the wrong face? Do we even know? And so unfortunately, it's sort of like a whole whack-a-mole thing where new forensic approaches are introduced by private companies hoping to turn a profit, or by crime labs trying to see whether some interesting new technology can make their work easier. Maybe it can, maybe it can't, but we need to know how accurate the stuff is. And so their work will never end. And that's what makes being a lawyer really exciting and interesting. The intersection as technology transforms lots of aspects of our lives between science and law has never been more exciting or challenging. But I'm hopeful, and with a lot of lawyers that are far more scientifically literate than we probably were taking on these issues, I'm expecting great things in the years to come.
Well, thank you so much, Brandon and Erica. And I would definitely like to echo the point about the importance of scientific literacy, technological literacy. And that is something that we at the University of Baltimore School of Law really try to produce. And Brandon, you've made a great contribution to that by producing this book as well as your other books. But on this particular topic, I think this is going to really help people be interested in becoming literate and help them down that path. So with that said, I see that it's gone to 6 o'clock. I want to thank Brandon and Erica, as well as Chris and Jason and Dean Weish for organizing this. Thanks to everyone for attending. Again, my apologies for not getting to the questions in the Q&A box, but thank you for your participation, and bye everyone.